All right, so I'm going to need you to speak up so that the court reporter can hear.
Okay, right from the jump you can feel how tense this is. Anytime the court asks someone if they object to appearing by Zoom, it usually means the stakes are already high. And with appeals involved, oh yeah, this is about to get interesting.
Do you have any objections to appearing by Zoom?
No.
All right. And Norma, do you have any other paperwork on this? All right, Mr. Alejandro. The reason why this hearing is taking place is because the Court of Appeals are seeking to determine whether or not you wish to continue with the appeal of your conviction and sentence in this case. Do you understand?
Yes, ma'am.
All right, could you raise your right?
Notice how quickly the judge goes into oath and verification mode. This is standard, but it also signals something deeper. The court needs to be 100% certain the defendant understands the consequences of ending an appeal. Once you drop it, there's no going back.
Right hand for me, please.
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Raymond Alejandro Jr.
And what is your TDC number, please?
0245-1676.
And counsel, do you stipulate that this is Raymond Alejandro Jr.?
Yes, Your Honor.
All right, do you have any questions?
Yes, Mr. Alejandro, it's just to start off, you want your appeal to be dismissed. You no longer want to go forward with your appeal. Is that right?
Correct. It is at this time I wish to no longer move forward with my appeal.
Okay, and we had a conversation in mid-August where you and I spoke over the phone, and you had said the same thing. You wanted your appeal to be dismissed. Is that right?
Correct.
And I think you've gotten some letters, but you just haven't been able to get them notarized at the prison facility. Is that right?
Correct.
Okay. But you have received those letters, but the only reason...
Small detail, but important. Notarization issues in prison happen all the time. It sounds minor, but it can literally stall someone's entire appeal process. What do you all think? Should prisons streamline this better, or is it just part of the system?
You haven't been able to send it back is because of the notarization problems. Is that right?
Correct.
Okay. But as of today, you still want your appeal to be dismissed and the conviction and sentence to stand.
Correct.
All right. Thank you.
All right, is there anything else you wish the court to know, Mr. Alejandro?
No, ma'am.
All right, then what will end up happening is I'll have a record prepared. This will go to the Fourth Court of Appeals, and they will be informed that you no longer wish to appeal. Is that correct?
Correct.
All right, thank you.
Thank you.
All right, thank you, counsel.
Mr. Ramos would like to approach his buddy with
Yes.
an answer from the dog.
All right, you have an answer on Mr. Escobar?
Double A bonds, they're
Mhm.
willing to reinstate him, so
Okay.
long as his family goes pay a reinstatement fee, which they're willing to do.
Okay.
And we're prepared to go from
All right, Mr. Richard Esquivel, if you come up, please. All right, so before we start, I see that the bond forfeiture was in October.
October.
You might want to check with the clerks and make sure that an ISI hasn't been put in the system, because if it has, I can't reinstate. So, Adriana?
Yes, ma'am, when I printed anything like that on the jersey.
Morning, I didn't see
And
Okay.
that, and when I printed out the two documents, the motions, that's all that was there on the indication on the signature.
All right, so we're gonna go on the record in a moment, but here's the thing. Your counsel is telling me that the bondsman has no objection to the bond being reinstated, which would mean that they would be back on the bond. But if for some reason there is a discrepancy in the system where there's a NISI that's floating around somewhere, it'll come to the court and your counsel will remind me of this. And I will not sign it if the bondsman does not want me to sign it, okay? All right, the court is calling 2025 CR 011324 State versus Richard Esquivel. Can I have parties announced for the record for the state?
You can already sense the judge shifting gears here. Bond reinstatements are tricky because one wrong note in the system, one ISI, one clerical error, and the whole deal collapses. This is where courtroom paperwork becomes a battlefield.
Defense?
Christopher Ramos.
And are you Mr. Esquivel?
Yes, I am, Richard Escobar.
All right, Mr. Esquivel, you were due in court on October 27, 2025. You did not appear. And at that time, the court issued a bond forfeiture and remanded you without bond. So counsel, if you could call your client for purposes of his lack of appearance.
Yes, Judge, for the benefit of the record, the defense calls Richard Escobar.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. All right, you can lower your hand. State your name for the record.
My name is Richard Escobar.
All right, you may proceed.
Richard Esquivel, at this moment, you are aware that you had a court date on October 27th, 2025 that you did not appear on, correct? Yes. And for the benefit of the record, that court date would have been your very first court date in this court, correct? Yes. And that court date would have been the first indicted setting after your arrest back over the summer, correct? Yes. Okay, that's correct. So since your arrest and since October 27th, you had not had any court dates or court appearances, anything like that, correct? That's correct. And you had not received any notice? No notice, and I might have done oversight in my part, but I can guarantee that no oversight. So let me ask you some questions, okay? And you and I have had discussions that the phone number I received from you from the appointment system, I've been calling, and you told me it was incorrect. So when we first met, we finally met up to resolve the situation. Yes. And since that time, has the bond company either complained or said anything about that you're not in compliance with? No, not at all. I've reported to the bond like I was to, and in person on other occasions or through a video, phone picture that we can send in. So we're almost done. I'm going to ask you two more questions. Were you aware of the October 27th court date? I was aware that you had to come in. That I had to come in. I was not fully aware that I was supposed to come in. With the court date was coming, but you didn't know. You knew you were going to have to come to court at some point. You just didn't know when that date was. Right. Did you willfully not show up to court? Willfully, no. I did not willfully not go to court. I wanted to. If the court reinstates your bond, do you promise to not come to every court setting from here on out? Yes, I do. I will.
Right here's the moment that decides everything. The judge is probing intent. Did he miss court on purpose or not? That single question can mean the difference between freedom and being held without bond again. And honestly, his answers feel nervous but sincere.
This prosecutor may have some questions for you. Do your best to answer her question. Yes.
Any questions?
Yes, sir. So, what date did you learn you missed your
When I was arrested.
Okay, when you were arrested, was it because you voluntarily surrendered? So,
On the other side, they asked me to up to the door. I'll go to the gate. I was looking trying to, drive in a car, I should have and the open the gates. I put up my dogs and stuff like that. So, put us in that kind of stuff. This special here.
All right, thank you.
No further questions.
All right, the court is going to find that the defendant's failure to appear was not willful. Based upon the defense counsel's representation that the bondsman is willing to continue to be on his bond, I'm going to reinstate the bond and have the warrant recalled.
For the benefit of the record, I just spoke to Adriana. She's described as the legal specialist according with AA Best Bonds, and she indicated that she stated they were going to remain on the bond so long as his family reported by the end of the day to pay a reinstatement fee.
All right, so what I'm telling you is I'm reinstating your bond because your bondsman wants your bond to be reinstated. Your contractual obligations with the bonds person, that's between you and the bonds person. Now, usually if you don't follow through on your contractual obligations with the bonds person, they will send to the court what's called an affidavit to surrender surety, which means they're going to want to be off your bond. They're supposed to notify your counsel that they want to get off the bond. And then that document will come to me. And normally in this court, what ends up happens when I have affidavits to surrender surety. Sometimes I know things get crossed in emails, things get crossed in faxes. So I usually have an email sent out to the defense attorneys or have defense attorneys called and saying, the bondsman wants off your client's bond. You understand?
Yes.
So, yes.
Yes, I'd like to state that I'd like to retract. I had submitted or to have my conflict changed, but I want to retract that because I was not clear as to what was occurring, and now I believe there, and I want to make the council that.
All right. And then what I will tell you is that sometimes, because I've been a defense attorney, you'll have a client who gets arrested. They don't understand why they're being arrested, and their knee-jerk response is usually, my attorney didn't do something. But normally that's usually not the case. So from here on out, stop with do a clear head and go through steps to figure out logically what should be done. You understand?
This is actually a great teaching moment. Judges know defendants often panic and blame their attorney when they're arrested. But the court reminding him to slow down and think logically? That's rare, and honestly pretty good advice for anyone dealing with the justice system.
Yes.
All right. Is there anything else?
No, Judge.
All right. So what we're going to do is we're going to give you a reset. State, where are we on discovery with this case?
Yes, Judge. And I think we do have a setting next week on the 15th, I think.
Okay.
And that's correct. If we can just keep that setting.
All right. And make sure that you, if you're able to tender an offer today. And Norm, if you'll give him a reset form, and counsel, if you'll make sure in the system that his address is correct, because that's where they'll send notice. All right. Is there anything else?
No, Judge.
Thank you. All right, Eric Cepeda. Charles, we are getting closer to Christmas. And my goal was to have my Christmas cards already sent out. That hasn't happened. And my mom's theory is whatever is happening that month, everybody should have everything the first of the month so you can display your Christmas cards on the mantle. All right, so today is his plea deadline day.
Judge, if you remember, we were on Zoom
Yes.
and we had asked for an extension of the plea deadline because
Yes.
of the DNA that we were waiting. And then it was brought up that the co-defendant said February the 26th.
See, I looked up,
Checked.
there's someone else. Maybe there are other,
Third co-defendant has said the 16th of this month.
yes.
So what we're asking for is just to come back on the 26th of February with the co-defendant. And hopefully by then this DNA will be back. But I just, like Mr. De La Guardia, I'm hesitant to have, we can't advise him on a plea until we get all the discovery.
All
So
right.
we'd like the same discovery date that the co-defendant has on February 26th. And on that day, if we have all the evidence, the DNA's here, then you can give us a plea deadline date shortly thereafter.
All right. This is what the court is going to do instead.
Yes.
I'm going to give you all a plea deadline date and a jury trial date. And if the DNA is not in by this date, then we'll cross that bridge when we come to it. I always say, let's not cross bridges until they've been built. So if you all will confer with Ms. Ferguson on a jury trial date,
Yes, Judge.
and all of you all are going to be set on the same date for jury trial.
Okay.
All right. So if you'll confer with Ms. Ferguson.
Will.
All right. Thank you. Thank you for dressing appropriately for court. And how long do y'all expect the trial to last?
conservatively a week, maybe a week and a half. I don't know. After that.
We're not first, aren't we? We're gonna try first.
Oh, I don't know.
So if you'll speak with Ms. Ferguson
Right.
and let her know that I would like these trials set in sometime in March.
Perfect. Thank you, Judge.
All right, Gage Guerra. And probation, this is an application. Court is calling 2025 CR 006868, State versus Gage Guerra. Could I have parties announced for the record?
Trey Maurer from Chicago.
All right, and counsel, are you the attorney of record on the case?
No, Your Honor, I'm standing in for Robert.
Do you have any objection to this attorney standing in for Mr. Maurer? All right, counsel, have you received all discovery? Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Mr. Guerra, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented? Mr. Guerra, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right. Did you understand you're charged with assault of a peace officer or judge as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Guerra, do you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,200 fine. The state is opposed to your applications. They're taking in consideration 2025 CR 006870 and 2025 CR 006869. There's to be restitution, if any, to Matthew Sparks, and there's to be restitution payable to Adrian Navarro, if any, under 2025 CR 006870. Restitution, if any, to Kevin Ramos, RAMOZ, if any, in cause number 2025 CR 006869. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No, Judge.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you requesting a PSI?
We are.
I need a date for PSI and TAP. All right, we'll be back on February 3rd. At that time, the court will make a decision on your application based upon any evidence that's presented to the court. All right. We're off the record. State, did you want the court to hold off on signing the dismissals? All right, let me give those back to you. I'll give those back to you so they won't get lost. You're welcome. Is there a need for a mental health evaluation or no?
Oh, please, Your
Have you ever been diagnosed with any type of mental health issues? Have you ever been on any type of medications for mental health? All right, thank you. You seem to pause. Have you been on medications for anything before? Okay, all right, thank you.
Judge, may I excuse?
Yes,
Thank you. Have a good weekend.
all right, you too.